When you post an opinion online, attend a peaceful protest, or simply practice your faith, you are exercising a right. These freedoms feel entirely normal to many of us today. They seem like a natural part of a modern, civilized society. Yet, their formal protection in the United States has a very specific origin story. This story begins over 2 centuries ago, with a debate about power and liberty. The Bill of Rights was born from a deep-seated anxiety that a new, strong central government might overstep its bounds. It was designed as a shield for the individual, a clear set of limitations placed upon the state. These 10 amendments were not afterthoughts, they were the very price of unity. The creation of the Bill of Rights was a crucial compromise in the early days of the American Republic.
After declaring independence and winning a revolutionary war, the nation's founders drafted the Constitution. This document laid out the machinery of a new federal government. However, many prominent figures felt it was incomplete, even dangerous. They argued that without an explicit list of protected rights, the freedoms they had just fought for could be eroded by the very government meant to serve them. This group, known as the Anti-Federalists, demanded a guarantee that certain liberties would remain forever beyond the government's reach. Their persistence led to the drafting of these foundational amendments. These principles were not plucked from thin air. They were the culmination of centuries of English legal tradition and Enlightenment philosophy. Ideas from documents like the Magna Carta of 1215 and the English Bill of Rights of 1689 crossed the Atlantic with the colonists. These historical precedents established the concepts of due process limits on sovereign power and fundamental human freedoms. The American Bill of Rights distilled these concepts into a concise and powerful declaration.
The First Amendment is arguably the most famous and frequently cited part of the Bill of Rights. It is a compact but powerful collection of protections: freedom of conscience, freedom of expression. It begins by forbidding Congress from establishing a state religion and forbidding the prohibition of the free exercise of religion. This creates a dual protection. Firstly, the government cannot establish an official state church, as many European nations had. Secondly, it cannot prevent individuals from practicing their own chosen faith or from having no faith at all. This separation of church and state remains a vital and often contested principle in American public life. The amendment then moves to protect freedom of speech and freedom of the press. It declares that Congress cannot abridge these rights. This means citizens are generally free to say what they believe, and news organizations are free to report on events and critique the government without fear of censorship or punishment. This freedom is not absolute, of course. The courts have recognized limits over time, such as incitement to violence or defamation. However, the core principle is that public discourse, even when it is critical or offensive or unpopular, should be protected from government interference. In the modern digital age, the First Amendment's protections are tested in new and complex ways. Consider the fierce debate surrounding online free speech. Social media platform X, formerly Twitter, social media platform Facebook. These platforms have become the new public squares. When these private companies remove posts or ban users for violating terms of service, it raises difficult questions. The First Amendment directly restricts only government censorship, not the rules of a private entity. This distinction is at the heart of modern arguments about whether these powerful platforms should be regulated more like public utilities, or whether they retain the right to moderate their own content as they see fit. They shape arguments in courtrooms, fuel debates in legislatures, and define the boundaries of public discourse. From the right to carry a firearm to the privacy of our digital communications, the issues may have changed, but the core principles remain the same. This essay will explore what the Bill of Rights really says, amendment by amendment. We will examine its historical context and, most importantly, explore why this centuries-old document still matters so profoundly in our complex, modern world, touching on everything from gun rallies to the very nature of online speech. The Second Amendment is one of the shortest and most fiercely debated amendments. a well-regulated militia, being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. For centuries, the interpretation of these 27 words has been a source of profound division. One school of thought focuses on the opening clause, organized citizen militias like those that fought in the Revolutionary War. From this perspective, the right is not an unlimited individual entitlement, but rather a collective one for the purpose of state defense. The opposing interpretation places its emphasis on the second half of the sentence, the right of the people to keep and bear arms. Proponents argue it protects a fundamental, pre-existing individual right to own firearms for various purposes, including self-defense. They see the militia reference as an introductory justification, not a limiting factor. This interpretation has gained significant ground in recent decades, culminating in landmark Supreme Court decisions that have affirmed an individual's right to possess a firearm for traditionally lawful purposes, such as self-defense within the home, separate from any militia service. This constitutional friction is vividly displayed in contemporary American life. Gun rallies have become a common feature of the political landscape. At these events, citizens gather, often openly carrying firearms where legally permitted, to protest proposed gun control legislation and to advocate for what they see as their sacrosanct constitutional right. The Third Amendment is perhaps the least litigated and most obscure of the 10. It states, "No soldier shall, in time of peace, be quartered in any private house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." This may seem like a peculiar concern to us today, but it was a deeply personal grievance for the founding generation. They had endured the British practice of forcing colonists to house and feed soldiers in their private homes. This was seen as an outrageous intrusion on domestic life and a symbol of oppressive military occupation. While soldiers are no longer forcibly quartered in private homes, the Third Amendment's underlying principle remains profoundly important. It helps to establish a broader constitutional right to privacy and the sanctity of the home. It serves as a structural support for the more frequently invoked protections found in its neighbouring amendment, the Fourth. The Fourth Amendment provides a much more modern and relevant protection for privacy. It secures the right of the people to be secure in their persons, houses, papers and effects against unreasonable searches and seizures. It further states that warrants authorizing such actions cannot be issued without probable cause and must specifically describe the place to be searched and the persons or things to be seized. This amendment is a direct response to the hated writs of assistance used by British officials, which were general warrants allowing them to search anywhere for anything without specific justification. Today, the Fourth Amendment is at the epicenter of legal battles over modern technology. The core question is how to apply the concept of persons, houses, papers, effects to the digital world. Does a police search of your smartphone's data require a warrant? What about your location data tracked by your car or your phone, or the vast amounts of personal information stored on cloud servers? Courts are continually grappling with these issues, trying to determine what constitutes a reasonable expectation of privacy in an age where our most intimate papers and effects are intangible streams of data. Well, that's where things stand. The Fifth Amendment is a bundle of procedural protections designed to ensure fairness in the criminal justice system. Nor shall be compelled in any criminal case to be a witness against himself. This is the origin of the right to plead the Fifth. It prevents coerced confessions and keeps the burden on the state. Nor shall any person be subject for the same offence to be twice put in jeopardy of life or limb, once acquitted, not retried for the same crime by the same government. Serious federal crimes must be charged by a grand jury indictment. No person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. It allows roads, schools, parks, but requires public use and fair market value. The Sixth Amendment provides a blueprint for criminal trials, speedy, public, and by an impartial jury. It ensures notice of charges, confrontation, and cross-examination of witnesses, compulsory process, and the assistance of counsel. The Seventh preserves jury trials in certain civil cases, trusting citizens to decide private disputes. The Eighth, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. It underpins challenges to the death penalty, certain prison conditions, and methods of execution. Today, on the 16th of October 2025, words written in 1791 continue to resonate with astonishing force. The final two amendments serve a different purpose from the preceding 8. The ninth is a rule of interpretation. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Our rights are not limited to those written down. One cannot possibly list every right. People retain a vast reservoir of unenumerated rights. While rarely the sole basis of decisions, its spirit influences arguments for a constitutional right to privacy. The 10th provides the capstone. Powers not delegated to the US nor prohibited to the states are reserved to the states or the people. This is federalism in a nutshell, a federal government of limited enumerated powers. We see it whenever state leaders challenge federal mandates. A state may pass environmental or healthcare laws that differ from federal rules, arguing authority under the 10th. Courts are asked to draw the line between federal and state authority. These disputes are a healthy and intended feature, ensuring constant negotiation of power. They intersect with debates over arms, speech online, and state sovereignty, conservative concerns among others in the national conversation. It channels disagreements into courts, legislatures, and civil debate, rather than allowing them to fracture the nation. The Bill of Rights, drafted with quill pens on parchment, remains profoundly central to the American experiment in the 21st century. It began as reassurances, a compromise to unite a fragile nation, placing clear limits on government power. Each amendment addressed fears: religious persecution, censored press, disarmed populace, intrusive state, unjust legal systems. Today, these principles meet global platforms, advanced weapons, and vast personal data, challenges their authors never foresaw. Its elegant simplicity allows adaptation to new technological and social realities. Tensions between liberty and security, the individual and the public good, state and federal power are dynamics to be managed, not problems to be solved. The document provides common ground, channeling disagreement into calm debate, legislative action, and judicial interpretation. It enshrines a healthy skepticism of power and an abiding faith in individual liberty. It offers a framework for argument and shared values, not gifts from government but inherent rights, a living document shaping a more perfect union.